actually in, I can't remember if it's Clayton Fayette County Jail, yeah.
So Deputy Gordon, you know, we're presiding this week. We are. So if people walk in saying, hey, what's going on? The answer is we're going on all week.
Mhm.
But I saw you later.
Awesome, okay. I'll find out if they brought him over, or if he's still in.
I don't know if you can. I don't know how they can.
All right, let's get started. We have I think it's labeled an inquiry calendar. We can see what we can do with the cases on there. The first two positions are Mr. Meister. He's back.
Yes, Judge. And we have a negotiated resolution. Miss Nix, I don't think, yeah, so I just talked to her. I didn't know if she had to be here since it's negotiated. Who's going to pad. So we just need to structure our outcome so that it doesn't mess up the plan. His mother will also be logging in. I see her on there. I think it's best though if we don't let him know that she's on. I think she's gonna switch her name over to guest.
Okay, I don't see her.
She's under Sean.
Oh, okay, got it.
Yes.
All right,
So she's in support. She knows what's happening.
good. She and I have met before.
Yes.
So do we need Ms. Nix or are you up to speed on Mr. Meister?
Judge, I am contacting Ms. Nix.
We're working on it. Excellent. Okay. We'll come back to that when we get Ms. Nix, or she lets one of the other ADAs know what's happening. But talk to me about the pad part, because that can't be a condition of probation. It's reinstating probation and then we're hoping he goes to pad, or what is it that you and Ms. Nix talked about?
He's linked up with Pad.
Mhm.
So I think I submitted a transport order already.
You did?
They're eager to get him this week.
Okay.
Ms. Ross also has linked him up with Grady Outpatient Services as well as a safety measure in case something falls through with Pad.
So we could put in the modification of probation that he continue to work with Grady Outpatient Services.
Yes,
Okay.
and I don't know if he has a mental health probation officer. I would be requesting one.
He needs one.
Yes, Judge.
Okay.
But my thought was he's been in over a year, so
Yep.
we could just revoke that and then reinstate.
So it's not a Grady Act team, but it is Grady Outpatient Services.
It is, yes, and I will confirm the name of it with Ms. Ross.
Okay. And what about, I don't remember, I can look back at the sentences, but contact with family, is that still, he needs to, am I gonna say nothing about it, or?
Oh, I think, so we're doing a permanent stay away from the named, so that would be the Diana, I can't remember her last name, and then the therapist. The permanent stay away is not for the family members. I think if we can structure, just remind him to only have contact with them if they want contact.
The family?
Yes.
Yeah. Okay,
Yes. Okay, thank you.
excellent.
I appreciate that.
We'll stack them.
All right, we will come back to Mr. Meister as soon as we figure out about representation for the state. How about Melvin Samson?
Morning, Your Honor, Michelle Ruff, a parliamentary veterinarian on this case. I believe that there's a bench warrant for him, that's why he's still moving out. And I filed a waiver of arraignment as well. It appears that he was in Clayton County Jail at the time that the bench warrant was issued here. So I am trying to pull those dates up to confirm, and the state has said that they would consent to him being, that bench warrant being recalled.
Once you get that information?
Yes.
Okay, yeah, that was a while ago. It was August 23 that he missed court. So I guess this bench warrant was lurking he had plea and arraignment on August 11th of 2023, didn't make it, maybe because he was in jail in Clayton County. I don't know if he was in custody elsewhere or if this bench warrant just didn't ever catch up with him.
It may have been that it didn't catch up with them, so because we thought it was the February date.
Okay, I'll look again, but when I was prepping on Friday for today, my note showed that the date he missed was August in 23. And then this is an old case. His arrest on this original charge is from 21. It got indicted in 23, assigned to me, and he missed plea and arraignment in 23. And I think the bench warrant had been out there. That doesn't mean, I'm not suggesting he's a fugitive. My guess is he didn't, well, if he was in Clayton County Jail, he couldn't have come to court. He also might not have known he had court because of the lag from when he was arrested on the charge to the indictment. He may have changed addresses, and so he may have thought, this case went away. Nothing happened for 2 years.
I'm pretty sure he didn't think it went away.
Okay.
His family hired me on the underlying charges.
Way back when or just recently?
Just recently.
Well, but that's because he got picked up on a warrant.
But they thought it was a recent warrant. They didn't know he had court. So I'll get those dates straightened out and then we'll figure out what we can do. Because
Sure.
he wasn't on the run.
So I'm not suggesting he was on the run, but there's been no activity in the case since August of 23, when I signed the bench warrant. The family became aware of things in February because he got arrested.
Right.
I don't know why he got arrested, if it was on this warrant or if he had another encounter with law enforcement, but when they ran his name, it would have shown this warrant. So regardless, that's how he got scooped up. But to me, that's consistent with Mr. Samson not knowing the case was out there. If the family wasn't reaching out to you until February of this year, he wasn't thinking that something from 2021 was still around. So, all right, so do you think you will, let me take one step back. Deputy Gordon, do we have all the folks up now?
Everyone is female.
Okay. Do you think you're getting that information today, or should I bring Mr. Samson to the door to say, hey, here's what's going on? And we don't need to bring him back. If you can get that documentation, Ms. Dilligard, who will be your ADA on the case, I think, is it not that kind of aggravated assault?
It's my case, Judge.
It's your case. All right. So if she's satisfied with the paperwork, I can just get an email from the two of you saying we're good, and then we'll just reinstate the bond and lift the bench warrant.
So it's what you're telling me, Judge. I don't think that I'll have that paperwork. And I do believe it was that he forgot, so he will need to speak with the court. And also I'll need to speak with the ADA and speak with him.
Oh, because you're not thinking he was in Clayton County Jail way back in August of 2023. Just recently he was in the Clayton County Jail.
Correct.
Okay, that's why he's here. So he got arrested for something in Clayton, unrelated to this, and then they can't let him go because our warrant was here. So you do need to talk to him, figure out why we didn't connect in August of 23.
Correct.
Okay, then we'll circle back after you've had a chance to talk to him, and we can deal with it today.
Perfect.
All right. All right, so we'll circle back to that. Check one more thing. Got it. Okay, Antonio Holmes.
I would need to talk to him. I'm sorry, I didn't realize he was going to be mine. So I'm going to talk to him and see if I'm assuming he missed court at some point. That's like the inquiry calendar.
I don't know, let's look. Maybe he can just work his case out. Let's see. Oh, he was in non-complex. And then there was a motion to revoke his bond from the state, but in non-complex. Because he got new charges while he was on bond in that case. It only got transferred here in January. So because he has another case here. Let's look that one up. 224. Would Jessica Jones be someone from your office?
Yes.
Okay, yeah, so he has a case here. They're both on the inquiry calendar. Huh, look at that. I'm sorry, position 5. I didn't turn the page. Same guy. And so we have the 23 SC. It's a palm off from non-complex. So I think we could call this plea and arraignment. I don't want to rush you and Mr. Holmes, but the position 5, this is the first time it's appeared on anything. He was indicted at the end of January. So why don't we treat this as plea and arraignment for position 5, and you can, maybe he wasn't able to make bond in this newer case. The bond amount is 25,000 cash from mid-November. So anyway, why don't you chat with him? Let's make sure we do the arraignment or a waiver for position 5. We don't need to do that with 4. It was apparently ready to hit a trial calendar in non-complex. So it'll follow along. All right. Marie Hamilton is not here yet. Who will be working with Ms. Hamilton?
She will be mine, Judge.
All right. So Ms. Hamilton was in drug court with me, and her addiction is very strong. We got her even into an all-female inpatient treatment center, and she walked away from that. Pardon me?
And that's why I'm here. She also
Okay, got it. While she was in jail?
when she walked away.
Okay, that's how, and that's how she got picked up. All right. It's unindicted? Okay.
I can fix that if you want me to.
Well, I'll let you and Ms. Wood talk about it. It'd be great to have all our stuff moved together. But this is here because drug court didn't work out. I think she was in drug court on a diversionary basis, so it came back to me. She's been pretty upset about stuff. Have you met with her yet?
Not yet.
Okay. She might not be real warm and fuzzy at the beginning.
Thanks for the heads up.
Sure. All right, so we'll come back to that when she is brought over. She's Miss Hamilton's just coming from the city jail, yes? Okay, great. So we'll see her today. Nathaniel Cargo.
We have a movie there to work out now. I need to talk to him to go over his rates.
Great. Kenneth Jones.
He's mine, Judge. I think we will be able to work his case out today. He's also got a probation matter I'm hoping to handle as well. I just need to speak to him and the
Okay.
state.
All right, and this looks like one that just got slid to us because he's supposedly a repeat offender.
Yes.
Okay. And then Ruben Rainey.
He's also mine, and we should be able to work this out as well.
All right, that's all I have for this morning. So why don't I come back out when we're ready on any one of these? Is that fair?
Yes.
Okay, sir, you are here for one of these cases?
Brendan McCarthy, I was here.
Oh, right.
And I'm sorry, I got stuck on the connector for her now. It's just to try and learn your system on the Zoom documents.
Okay. I'll talk to you in a sec.
Thank you.
And ma'am, I think you're here for Mr. Samson? Okay, great. And here comes trouble. That is this afternoon, and it was for bond, but his lawyer cheated the system, and he has charges where only a Superior Court judge can hear bond, and he needs to be in the line he's supposed to be in. So I'll be sending an email to that lawyer saying, don't come on down here today. You can keep him up, and I'll explain that to Hutchins. I'll put that in the email, and when that lawyer says, gosh darn, but okay, then I can let him know his lawyer worked very hard and cut in line, but has to get in the appropriate line.
Okay.
Okay?
So
What's going on, Mr. Walker? Did you have something here this morning? Sure, always.
One judge,
Hey,
I don't know if you heard it or not, but I'm here on behalf of Ted Johnson.
yeah, no, I got the email that you and Ricky were helping out. He has one of my older cases that he took over for Tanya Miller because she wasn't doing well. And then he stepped in. What's going on?
Judge is pretty tough. Ted, 10 years ago, had cancer in his kidney, so they took that kidney. He went to visit his kids earlier the month.
Back on. Ms. Wood, you ready to have Mr. Meister come out?
Yes.
Great. Should he come to the podium?
Yes.
All right. When Deputy Gordon, maybe you can knock on the door. I don't think he knew we were going to get started back up.
Judge, it doesn't sound like you necessarily need me.
I don't think so. If Ms. Dilligard is happy covering for you, we're happy to have seen you and tasted your baking wares. You are free to roll on to your next stop.
Text me if something changes.
Okay, sounds good.
Thank you.
Hey, Mr. Meister, if you'll come right up there to the microphone. Good morning.
Good morning.
Good to see you.
It's good to see you as well.
Ms. Ross, are we handling Mr. Leach this morning or this afternoon? Or no?
I could handle him this morning, but you know, he's not here until one.
Okay.
He's here, he's just, I just didn't bring him.
Oh,
Okay. No, I'm happy either way. I just wasn't sure. I remembered that I didn't get that calendar, or it's not attached to the thing I look at. But you had sent an email about him. We'll do him today at some point, whenever works. All right. Good morning, Ms. Rivers.
Good morning. How are you?
I'm well, glad to be out of the rain. We're going to go on the record. We have Mr. Meister out here. He has two cases, a 17 SC case and a 19 SC case. Mr. Meister is here with Ms. Wood, and we have Ms. Nix for the state. And Mr. Meister, you have been in jail for a long time, as we have collectively, you've been helping. We've all been working together to figure out what's a good setup for you when you're released. And if we rewind for a while, I can remember at one point you were thinking about maybe getting into a school to get some emergency fire suppression training, et cetera. That didn't work out, and I think I understand why. But Ms. Wood and Ms. Ross, you may remember meeting with Ms. Ross, and you have lined up support from PAD. And they will be, assuming we get through everything today, they will be coming to get you on Thursday. I've already signed a transport, well, it's a release order, releasing you to PAD personnel, along with your medications. Don't leave without your medications. And then you and PAD are going to take care of things from there. That's my understanding. But of course, that needs to be what your understanding is and what Ms. Wood is advocating for. But I just wanted to lay the groundwork of what I think we're doing this morning. Okay?
Yes, sir.
All right. So Ms. Wood, my understanding is that Mr. Meister is admitting to having violated his probation, and we're all acknowledging that he served about a year in custody as a result of that. And
Yes.
yeah, I'll get more precise by clicking a few clicks here. And you get 456 days, so a year plus 3 months, so a minute, as they say. But that the consequence of the probation violation would be to revoke a year plus, and then have Mr. Meister released to PAD on Thursday. And I'll talk about a few more tweaks that we're going to get in there. And I think I may be signing a permanent stay away order as well. I don't have that paperwork right now, but I want everyone to know what's coming. So why don't you take it from there?
Thank you, Judge. Yes, so we are admitting to the violations. He has been in custody 456 days. We have gone over extensively that permanent stay away order. Ms. Primovic also went over it with him. He's met with Ms. Ross a number of times. We are excited that PAD is interested in working with him. It's been quite a journey to get to this point. He worked with some Emory doctors and then Dr. Norman. And we feel that he understands and is eager to work with PAD as well. He's also going to be working with Grady's ICM program. I can't remember what ICM stands for, but I talked to him about it in the back, and he is eager to get hooked up with them as well, Judge. So we're asking that you revoke the 456 days and reinstate to probation.
Okay, I will do that. remaining on the 17 SC case is 1 year and 9 months. If I were to revoke 1 year, I need to revoke enough to get us through Thursday. So let's just say hypothetically, I revoke 1 year and 3 months, only 6 months remaining on the 17 SC case. My thought was we could just close that one out because there are 5 years remaining on the 19 SC case. So again, if I revoke 1 year plus, you subtract that out, but that has the much longer probationary tail. And then we're just dealing with one case, which is just easier for everyone, I think. I need to hear from the state. They may have a concern about that. But I'm assuming you and Mr. Neumeister would not object if I closed out that oldest case.
That's correct, Judge.
Okay. All right. And you mentioned that there had been discussions about the people from whom Mr. Neumeister needs to forever stay away. That's not family members, and we'll talk about that some this morning as well. I'm just pulling up the other final disposition because the name on one didn't match the name I thought we were talking about.
Is it a last name, Judge? Because I believe it changed.
Oh, maybe that was it. Yeah, because the oldest case is, you need to be careful around family members. The newer case was a Catherine and then a hyphenated last name, but I didn't hear that last name when we were talking earlier.
I believe so. I thought, I don't have it in front of me. Do you have it with me, my name? I thought one of them was Diana, or a name that started with.
You mentioned that, but what
Okay.
in the 19 SC case, the requirement was that Mr. Neumeister stay away from Catherine Sussman Schwartz, hyphenated, or her husband.
And that's correct. I think I'm confusing because I went through a lot of the transcripts from previous probation revocations.
Mhm.
I think that person might be tied up with the DeKalb County case, Judge. So I
Okay.
apologize. So, but yes, that's the correct name that you're referencing.
Okay. Now, there were some protective orders out there that are referenced in the older case, but it just says family members or non-family members. It doesn't have names. It just says comply with those. So there could be a Diane,
Yeah.
whatever, but the specific name that was in the more recent case is that Catherine Sussman Schwartz. So, okay. Ms. Nix, what are your thoughts about closing out the 17 SC case? So revoking 1 year plus and then terminating.
Judge, I'm fine with that, as long as the other case does remain open. I would ask that the conditions of, that he get a mental health probation officer, and that if it's not already a condition, that he stay on his medication, comply with any aftercare from the is it ICM
Yep.
program, or compliance with the ICM program, and any aftercare if he does complete that program. And then the permanent protective order, which I will provide to Your Honor here in just a moment. The names that I have are Catherine Sussman Schwartz, Jonathan Schwartz, and Dana Elizabeth Miller. Those are the names that I have.
Okay, got it. That all makes sense. Ms. Simpson, anything you want to add? I know you shared, I think Ms. Nix wasn't here yet, that Mr. Neumeister has had and will continue to have a probation officer attuned to his needs and his situation. Okay, so we'll maintain that. Okay, I think I understand all this. Mr. Neumeister, do you feel like you understand it all?
I understand it right now. Will I be receiving documentation about any of this?
Sure.
Okay.
You will get, well, Ms. Wood will get and can get to you copies. For example, I'm going to be signing 3 orders, it sounds like, today. A revocation order in your oldest case that's going to revoke basically the time you've been in and then close that case out. So you'll see it says terminated. And then in the newer case, which is still an old case, it's going to revoke the time that you've been in, and then it will have those conditions we talked about, and then it reinstates the balance, indicating that you remain on probation. So those are the 2 probation orders. The 3rd order I'm going to be signing is coming from Ms. Nix, the prosecutor, And that's what we call a permanent protective order. And it's me saying in writing, basically, you forever need to stay away from Ms. Sussman Schwartz, her husband, and whoever that third person is. There is now a temporary one that can expire, or someone could apply to have it go away. The permanent one is the legal system's way of saying they go their way and you go your way. And you can't call them, write them, knock on their door, or anything like that. It just gives them an extra level of comfort. Okay. Those are the three things, and you get copies of all those. None of this is secret documents.
Okay, permanent protection, I absolutely understand and completely agree, and I'm fine with that. My only concern is that Atlanta can be a small town, and how I know some of these people, I don't know, maybe I'm 36 now, and that won't, I don't think I need to be concerned with that. I don't understand, I'm confused about this revocation. When you keep saying revocation, I'm not, I don't understand what you're referring, like
I'll try, let me try to explain, and then we will talk about it more. But I want to touch on the thing that you said, don't worry about it. Atlanta is big, but it's small. You are not in trouble if you are randomly walking down the street, not in the neighborhood where one of these people lives and you have no reason to be there. But let's say I feel like McDonald's, and you go to North Druid Hills. There's a McDonald's on North Druid. I'm going to go to one on North Druid Hills. And you walk into that McDonald's, and coincidence of coincidences, Ms. Sussman Schwartz is there. You just need to leave the McDonald's. That's it.
Okay.
Now, if you stay in your car and watch her get in her car and you follow these active efforts to be in her vicinity, that's a problem.
Okay.
But the purely random, you go to see a movie and she goes to see the same movie, you just have to go see a different movie.
I accept that. That makes, okay. Yes.
Now, in terms of this revocation, over a year ago, you got arrested because I had signed a warrant saying you were not complying with probation because of X, Y, and Z. I don't have that warrant in front of me, but we've talked about it a few times, and Ms. Wood is saying, no, Mr. Meister admits he did those things. And the only reason why we're still talking about this is that we've all been working hard to have a good, well, one, we had to get you stabilized. Because when I first saw you, you had been off the medication, and we connected a little bit, but it was pretty clear that you were a little bit out in the wilderness.
Yeah.
But you've stayed on your medication, things are stable, and so we're able to have this kind of conversation. So we needed to get you stable, and then Ms. Ross and Ms. Wood needed to find a place that you'd be connecting with so that I was comfortable. We weren't just having you hit the streets.
Yes.
Because your family, on their terms, want to be around you, but you couldn't go stay with them.
Yes.
And the notion, and you weren't going to go to firefighter school, I needed to have a for sure place you could be.
Yes.
And that's going to be PAD.
Yes.
And it's just taken a while because we under-resource taking care of folks who struggle with mental health. That is a societal ill. We spend a whole lot of money on finding a place for someone who shot someone else in the head. That's called prison. We spend lots on that. We don't spend a lot on finding a way to help keep you on board with your medication and engaging with people in a safe way. And so it takes longer. So all we're doing today is putting that final punctuation mark on you acknowledging I did a year plus ago violate my probation by doing those things. And Ms. Wood on your behalf is saying, nope, Mr. Meister admits he did those. That means I revoke some of your probation. When you're on probation, sort of a promise, hey, I'm going to do better than I did before. I had to come into court because I did these things. With Ms. Sussman Schwartz, you pled guilty to aggravated stalking. You had been told to stay away. You didn't stay away. There are consequences for that. You got arrested, you got locked up, and you pled guilty. One of the parts of your sentence was probation. Part of that probation was, I'll do these things. When you don't do those things, we revoke probation. It's like, hey, I told you to do it, you didn't do it, so you're going to go to jail for a little while, or a long while in your situation. That's the revoke part. It's the consequence for violating your probation.
So like when I when I was arrested, that means I was no longer on probation because I was now under arrest, which means now you have to document the fact that that time passed by. And so it has to do with the definition. I'm trying to figure out the definition of the word revoke for your and mine purposes.
Sure.
So it's like I get arrested, and Right?
So you're actually still on probation while you're in custody. That
Okay.
clock is ticking.
Okay.
The good news for someone who wants his probation to end,
Yes.
while you're stuck in jail, is that your probation clock is still running. But the revocation is the way we formalize, why were you sitting in jail for all that time? Not for giggles,
Okay.
not because we needed to help stabilize you, that's part of it, but primarily because you violated your probation. And so then we revoke a piece, and then whatever balance remains, and in the case we're leaving open, when we subtract that year revocation, there'll be about 4 years left of probation. But that clock is running right now while we're talking.
Yes.
And that time is shrinking, but you're going to get out on Thursday. So you'll still have about 4 years of probation left, which gives me some assurance that there's something I can do if, and I'm making this up, but if 6 months from now, you throw a rock through your mom's window because you're upset and you're in a bad space, the police can come, and then you and I have another conversation about, man, Mr. Meister, I thought you were in a better place. And maybe you were, and maybe you weren't. So that's how we're moving forward.
So like the title of the document, it's a revocation order, and that's literally to describe the fact that I've been in custody for a year. So that explains what's been taking place for the last year. Okay.
Correct.
Now, will I have another document indicating the remainder of my probation balance?
I don't know that it will be, is the balance shown on the revocation order, Ms. Simpson? No. You can talk with your probation officer, and he or she maybe could put something in writing. I'm telling you, and we're making a record right now, our court reporter is virtual, that you'll have about 4 years, you'll have a little less than 4 years left on probation.
Okay, so I'll have some documents indicating why I was here, a permanent protection order, which I'm completely fine with. The PAD program, I'm working out the housing with the PAD program. Let's say it's on Friday, I'm looking at the documents in my hand and I'm confused. Am I allowed to come back in this courtroom and wait and talk to you directly and say?
100%. You are. There's no protective order against me. You can come to court. You also can call Ms. Wood. So you have a couple resources. You may even be able to call Ms. Ross. I'm not going to volunteer that up because she's not as front line as Ms. Wood is. But courtroom AD is your courtroom. It's a public space. Now, we may be in the middle of something, and so you may need to wait a little bit before you and I can have a conversation. But if you're, hey, wait a minute, why is this happening? You should feel free to come to court. Deputy Gordon and I will work with you. If we don't have the answer, we'll figure out who we need to ask.
Okay, because right now I'm on good terms with my parents, but the arguments tend to revolve around who's going to pay for what. Just honestly, and so the likelihood that I show up here within a week and just is very high. Only because I'm trying to avoid asking them for money because that creates a series of logistical and conversation. Even asking my mom to put money on my books in the jail becomes an argument because it's constantly what I'm asking her for, and working out anything besides asking her for money would be great because I don't even have a cell phone right now.
Okay.
But I can find the courthouse because I can walk really far in Atlanta, and so
this is a safe place to come.
Okay.
And we can work through things. Now, we're not in a position to give you money, but we certainly,
not necessarily, but.
we certainly can work through things. And hopefully you're going to develop some good contacts at PAD.
Yes.
Where they can connect you with resources as well.
Yes.
Whether it's a way maybe to start working and then you're earning some of your own money so that you can take care of these things. But I also want you to know your family is there and your family cares.
Yeah.
And so there may be friction. What happens with families, but they are very interested in your well-being.
Yes.
And have been plugging into this process all along. Okay?
I don't have any more questions. Okay, so I'm going to Thursday, you'll probably see me within a week because I think I'll have more questions as soon as I go back in the holding tape. So I won't waste your time right now.
Sounds good. Again, start with PAD.
Okay.
When you get out, start with the questions with PAD. And if that's not getting you good answers, like I said, you're welcome to come here 9 to 5, Monday through Friday. We're around.
Okay.
All right, but we're not done. I've answered your questions for now. So what I'm going to do, Ms. Simpson, how do I structure this? I don't want Mr. Meister to be released before Thursday, but I also don't want to do the exact math because they may say, oh, we're going to release you do I need to revoke beyond Thursday and then there's the transport order? Or do I say release to pad? And that will be the indicator. We even know the date, release to pad on the 13th.
We can do it that way, so that way it's not a condition.
Okay, it's clearly not a condition on pad. Pad will not get heartburn over that. Okay, then let me look again at the numbers. Ooh, 365. Four months. Okay. Mr. Meister, as a result of your admissions that you violated probation in 17 SC 150312, I'm going to revoke 1 year and 4 months. You'll get credit for the time you've been in. The only condition on that case will be that you are to be released to pad on March 13th. That is 3 days from now. No?
Judge, no, I agree with you, but I just remembered I don't want him to get sent to DOC if that's the number we're putting in the order.
Well, I don't think he'd go to DOC between now and Thursday, but I also cannot.
Okay, got it.
I can also not sign the revocation order until tomorrow, and then it's just 2 days. But I don't think it'll move that fast.
Okay.
Good point, because it's more than 6 months. But it's 1 year and 4 months. You'll get credit for time served, and it's released to pad on Thursday, the 13th. And then I am terminating the balance of that case. So that case is closed once you go to pad. 19 SC 172125. I'm revoking 1 year and 4 months. You'll get credit for time served, which is just a little less than 1 year and 4 months. Released to pad on Thursday, March 13th. It will be a special condition of your probation that you stay on all prescribed medication. If you don't like how a medication is affecting you, talk with a doctor, but don't stop taking it. Say, doc, I need a different version of this medication. And you'll be required to participate in the Grady ICM program. That's outpatient treatment that PAD's going to help connect you with. And that will be the remaining special conditions. There's already in your sentence to stay away from Ms. Suzman Schwartz. That doesn't change anything. That was always a condition. I'm adding the stay on the medication and participate in the Grady ICM program and any aftercare. And then finally, I'll be signing this protective order that just makes permanent the stayaways of you from those 3 people. And I'm reinstating your balance on the 19 SC. That's what I told you, where you'll still have a little less than 4 years left on that, so that we have some supervision and you have different supports. You'll have a probation officer, you'll have Grady, you'll have PAD, and of course you've got your family on their terms, but you'll have your family. Okay? Ms. Simpson, anything else you need from me?
Judge, your supervising officer will remain the same to be Officer Cook, based on because she is specializing.
I've never met Officer Cook.
Okay, well, we'll make sure that happens. Should we get a phone number to Mr. Meister to?
Okay.
I wrote
Great.
it down, Judge.
Good, you're gonna have a phone number for Officer Cook. That's another one of those things where if you don't know where the probation office is, come here.
Yes.
And then we will connect you with, it's 2 blocks from here.
It's behind the ACDC, right?
Yes.
Okay. Yeah,
And so you should talk with Pat about how you need to go down there to plug in so that you can meet Officer Cook or however they want to manage that.
Yes.
Okay? So you said you can walk far, and if you can walk here, you can walk to the probation office. Okay? All right. Anything else, Ms. Simpson? Ms. Wood, anything else?
No, Your Honor, thank you so much.
Ms. Nix, you'll get that PPO to me?
I sent it to you via email.
Great. It's probably arrived. I've been focused on what we're doing here, but there it is. Great. I'll sign that. You'll get copies of things from Ms. Wood. You can get maybe some from probation. Do you have any other questions, Mr. Meister?
No, no. If I have more questions, I'll make my way here back to this courtroom once I'm not in custody. Because I will have more questions, but I won't remember them till tonight when I'm laying in bed. So
Sounds good. Good luck, my friend.
thank you, sir.
Thank you, Judge.
Mr. Johnson? One of you is Mr. Johnson? It's Ms. Johnson. Oh, I'm sorry. It's covered up. Miss Johnson? Yes, yeah, probably Mr. Johnson's not here. All right, I'm gonna sign this and get you on your way. You bet. How do you pronounce your first name? I like the first name. And your employer is, what do they do? Is that a law firm?
Yes, it's for veterans, like cases.
Are you a paralegal there or an attorney there or you?
Legal receptionist.
Okay. How long have you worked there?
Over a year.
Okay. All right. So I've signed this. All it means, you still have to go file things. It just means you don't have to pay the filing fee. Okay? Good luck with that. And sorry for the confusion. I didn't mean to call you Mr. Johnson. That just, your name was covered up by your license.
It's okay, thank you.
Take care. All right, Ms. Ruff, I'm ready for Mr. Samson if you are. Okay. If you want to come up to the podium, we'll bring him out.
Sorry.
No, it's not.
Good morning, Mr. Samson.
Good morning, Your Honor.
How are you?
I'm doing well.
Good. Mr. Samson, I'm Judge McBurney, and your case was assigned to me a long time ago. You had court in August of 2023 and missed court. I signed a bench warrant back then, and I guess that bench warrant just kind of lingered out there. And then you had something happen in Clayton County recently, and that bench warrant caught up with you. You got transferred here, and we need to talk a little bit about why you missed court in August of 2023, why I shouldn't be worried about you missing court again, because your lawyer would like you to be back on your bond, and we'll go from there. Okay, so I'm going to hear from Ms. Ruff. I may hear from Ms. Dilligard as well as the prosecutor who has your case, and we'll figure out what we're going to do. Ms. Ruff.
Good morning, Your Honor. Thank you. I am asking that Mr. Samson be returned to his bond. He did not know about the court date. He was incarcerated from December 2022 to June 2023. We're not sure of the exact dates at this point. I can get those. Do you want to explain why you were?
It was for a DUI and a fleeing and eluding charge
In what jurisdiction?
in Cobb County.
In Cobb. So basically Christmas time of 22 all the way through June of 23?
Yes, sir.
And it was low, you didn't go into the state system. You were in the Cobb County jail the whole time?
Yes, sir.
Okay. And was that because you were serving a sentence or?
Yes, I was serving this.
Okay, got it. And is that sentence over or are you still on probation?
I'm still on probation for it.
Okay. Is it felony probation or misdemeanor?
Misdemeanor.
All right.
And
Out of Cobb or for something else? For a different case?
It is for 22-9-2636. And that case is expired to December 2027.
Does it list the charges?
And he also has a violation of probation on that case.
Okay. Do you have more than one case out of Cobb or we're talking about the same thing?
it's 2-1. It's misdemeanor probation and it's felony probation.
All one case, so like the fleeing and attempting to elude would be a felony.
Right.
Okay, and you're on probation for that.
Yes, Your Honor.
Okay, but you got out in June.
Yes, Your Honor.
All right, let's keep going with the timeline, because then we were gonna meet in August, but it didn't happen.
So at that time, he was, and at the time of his arrest, he was still with his child's mother. He has one child, and they were living in Canton, Georgia, at 600 Preston Circle, Canton, Georgia. So he believes that the notice for this arrest and this case would have possibly gone to that 600 Preston Circle. But that child's mother had moved in with her mother, and he was in jail, so he moved, and he was living with his sister and grandmother for a very short time. Well, his grandmother had stated that she had received a call from the DA here in ADA, and they had said the charges were dropped. I haven't been able to go online. I don't know if they were actually dropped. I don't know. We don't know any of that. That's just what his impression was that he was no longer facing those charges since it was from 2021. He has moved in with his partner, Kayla, and they live at 950 Lake Ridge Parkway in Riverdale. We think that it would be safe to send any notices and keep his grandmother's address as his permanent address. She's raised him since he was 11 years old. His father is deceased. His mother is in Boston, but they do not have any contact. And his grandmother, as I said, raised him and his sister. His niece and nephew also live there. So he would, upon release, go back with Kayla, but then again, his address, and then now I'm involved in the case, so I would also be notifying him of any notices, and I have a lot of contact with Kayla, so that would continue as well.
What's Kayla's last name?
I'm sorry, Kayla.
Davis?
Yes.
All right, but you don't think, Ms. Ruff, we should use Ms. Davis's address as the address in the system for notices for Mr. Samson?
No, I think it's safer to use his grandmother's address. She's been at this address.
Are you planning on moving, Ms. Davis? You are, okay. Moving locally?
I would say further north in the area.
But not to like Kentucky,
No, of course not, in Georgia.
in Georgia? Okay, all right, and why are you moving?
I just don't like the apartment, the maintenance is just.
Okay, you don't like where you are, but, got it, okay. Does further north mean all the way up to like the border, or further north means going to Johns Creek or?
Yes.
Okay, got it, okay, understood. What's at 729 Fitzgerald Place?
That's grandmother.
Do you not know that address, Mr. Sampson?
Oh, no, I know it.
You know it, okay. I was asking you, what's at 729 Fitzgerald Place?
Oh, it's my grandmother's house.
Okay, that's the good address?
Yeah,
Okay, all right.
they have the house since 2008.
Who else lives there besides your grandmother?
My sister and her 2 kids.
Does your grandmother work?
Yeah, she works at Amazon.
And does your sister work?
Yeah, she works at Kennestone.
What about you?
Yeah, I work at in the Battery at Battle and Brew. I'm a cook there.
Okay. So you've been in about a month. Will that job still be there at Battle and Brew?
Yes, I talked to my chef. He says upon my release, I'm gonna still have a job there.
Okay. And how were you getting from Riverdale way up to the Battery?
Drives me or Uber.
Why do you drive him does he not have his own car? No. Do you have a valid driver's license?
No, it's suspended.
I'm sure you do, Miss Davis. I'm not worried. So that's part of that Cobb thing. You're not supposed to be driving?
Yeah.
Okay, then it's good that Ms. Davis drives you around. So your notice back in July of 23 went to that Preston Glen Circle in Canton. So that's why you didn't get it.
Yes, Your Honor.
Got it. Okay. That makes sense. Your bond in this case, assuming it's still, I mean, you haven't done anything wrong. It's just an old bond, and bonding companies sometimes kind of walk away from things. But your bond is from July of 21. And the only big condition is that you're supposed to stay away from Taekwon Gerald Bly. Do you know who that is?
Yes, he's my cousin.
Okay, have you been staying away from him?
Yes, we haven't had any contact.
Okay, I mean, just sometimes when his relatives, that's tricky because, hey, I'm going to my grandmother's house and my cousin's gonna be there and I can't be around him
No, I haven't seen him
since whatever happened.
Right.
Okay, keep it that way. So you've done a waiver of arraignment, Ms. Ruff. And so I think all we need to do is I will set aside the bench warrant, which will release Mr. Samson. And the address in the system is good. We don't need to update it. That's grandmother's place. And as long as you have good contact information, and you're in the system, so as long as you have good contact information for Mr. Samson, which it sounds like you do through Ms. Davis, then if he misses court again, it's on him because he's got a big network of people telling him you need to come to court.
Interesting.
Grandma, significant other, lawyer. You waived arraignment. Let me see what that looks like. Okay, and you've opted in discovery. So we'll enter a scheduling order this week, which gives the state, Ms. Dilligard, a deadline to get you discovery. Your motions deadline is tied to that, so you haven't missed any deadlines yet. That scheduling order, say here's when the state gets the defense discovery, here's the deadline for defense motions, if any, and then there's a final plea date. Mr. Samson, I won't see you again until we either have to argue a motion, it may be, and I'm making this up, but the police interviewed you and your lawyer thinks that they interviewed you in the wrong way and she wants to suppress that interview. But if there's nothing like that, then I'll see you for what we call final plea, which is the last time you could resolve your case by entering a plea and withdraw that plea if you don't like the sentence you get. Most cases are negotiated anyway, so you don't need to worry about that. And this may not be a case where you're pleading. You may want to go to trial. And that's what we would do if nothing happens at that final plea. Your main thing is to stay out of trouble. You are on probation, and you've used up your free pass here by missing court way back in August of 2023. So just make sure you don't get pulled over driving when you're not supposed to be driving or anything like that. And I will see you at the next court date. Ms. Dilligard, anything from the state? Ms. Ruff, anything else on behalf of Mr. Samson?
No, Your Honor.
Mr. Samson, any questions about anything we've discussed?
No, Your Honor.
Okay. Thank you, Ms. Davis, for being here. All right, you're good to go. So you will get out. If you don't get out, you're wearing orange. Are you being held at Cobb?
Yes, I'm being housed at Cobb, but
Okay.
I'm still in Falling.
No, I understand. We have some excess capacity up there. If you're not released today, it should be tomorrow. If you're going to bed tomorrow night at the Cobb County Jail, call your lawyer so she can figure out what we haven't done on our end.
Okay, thank you, Your Honor.
All right.
Thank you. This is all. May I be excused?
Yes, ma'am.
All right, thank you.
Ms. Wood, who had Holmes? Ms. Rios? Do you want to do Holmes now? What are we doing?
A bond hearing, so there was a bond hearing filed, and if your honor would be inclined to hear bonds, he said, like.
In which case?
The aggravated assault case, that's the only one that. And so it was a bond, motion filed in November, so I told him I would file one, he was a little, said he's been waiting since November when the previous attorney filed for him.
There was a petition to reduce bond filed in November. That's the thing you're relying on as the motion?
Yeah.
Okay, got it. You've done a waiver and an entry, so we'll get that taken care of. Ms. Charles, is this your case?
Yes, Your Honor, it will be.
Are you comfortable talking about bond?
Your Honor, the state's position would be that Mr. Holmes already has a reasonable bond set. And as far as the conditions that were present in November, the state there's been no material change. It's, would ask that you keep
Okay.
on as is.
Well, why don't we, I hear you on that. So two things. One, we'll bring Mr. Holmes out. We can hear that. I may end up agreeing with Ms. Charles. Because you may not have known we'd be talking about bond today, you may want to reach out to Ms. Hunter. So I won't make if I was inclined to change anything about the bond, I would condition that on you having an opportunity to reach Ms. Hunter so that her input could be shared with everyone. Great. All right. And what about the older case, that's just going to follow along with the newer case? All right. So we'll get a scheduling order for the newer case. Do you have discovery for the older case? Would that have come to you through the non-complex lawyer?
Email the non-complex lawyer to see if he could send it, but I don't know what's going on. I don't know even if he's got it. Sometimes there's issues with non-complex, so I don't know.
Right. So I guess this will be split in the DA's office because Ms. Dilligard, you'll handle the drug case and Ms. Charles will, but if it's a universal resolution, one of you can do that. Okay, all right. We're ready for Mr. Holmes, please. One second. All right. Mr. Holmes.
Yes, how you doing?
I'm Judge McBurney. Nice to meet you. Your case 25 SC 000224 has been assigned to me. And that means that you had an older case in non-complex that has been sent here as well, so that all your cases are in one place. Ms. Rios will be handling both those cases for you, and I'll be presiding over them. Your lawyer on the more serious case, you're charged with shooting at someone. That case, I'm gonna call it the assault case. It's just an allegation, but that's the allegation. Your lawyer that you had before it was indicted filed a motion to reconsider bond. You were given a bond by Judge Brooks in November of last year. And I guess that's too much. You haven't been able to make it, meaning post that bond. But Ms. Rios is going to talk to me a little bit about that. I'll hear from Ms. Charles, who's the lawyer who is prosecuting, the prosecutor on your assault case. And then I'll let you know what we're going to do. Ms. Rios told me you already have a bond in your older case, the marijuana case. Is that correct?
Yes.
Okay. All right. So we're going to have that conversation. And regardless of what happens today, things will start moving a little faster. Ms. Rios has filed her entry and waived arraignment on your behalf. So she'll start getting the discovery in the two cases so she can meet with you to talk about what kind of evidence the state has. And if there are issues that she thinks she needs to file motions about, she'll do that and we'll work through those. Okay. All right, Ms. Rios.
Yes, Your Honor. Mr. Holmes is 50 years old. He's from Atlanta. He has 11 children ranging in ages from 27 to 2. Before he was incarcerated, he was working at Apply in industrial technology as a forklift operator and material handler. I'm asking for the bond to be reduced to no more than $5,000. That way we can go, and I know that's a low bond, but that way we can go for the bonding, the bail project. So hopefully he can get out and start working and taking care of all the children that he has. I don't know, I haven't looked in too much of the case since I just got it today, but it seems like it wasn't a situation where he, not going too much in the facts that a gun went off. It seems like it was the situation and there were other people around, but it wasn't a situation where I know based on the charges that to make sure it's not like the understanding that he just pointed the gun and shot at someone. So based on that understanding of the facts of the case and the fact that he's been in 5 months and he has a job that he can go back to, I'm asking for the $5,000 bond.
And if Mr. Holmes is able to make bond, whether it is the current bond or a reduced bond, where would he be staying?
The address that's in the system, the 2808 Torham Court. He lives there with his brother and his brother's wife.
Okay, and that's not where Miss Hunter is?
No.
Okay, is Miss Hunter the mother of any of your children?
Yes,
How many?
this is my 2-year-old,
Your youngest?
my youngest son. Yes.
Okay, got it. Another address I have associated with you is on McDaniel Street, 585 McDaniel Street.
That's an old address, yes.
Okay, is that where Miss Hunter lives?
Oh, no.
Okay, so she doesn't live there and she doesn't live at this Torun Court?
She does not.
Okay. All right. I think I understand all that. Ms. Charles, I know you are being called upon without a whole lot of notice that we'd be talking about bond, so I'll keep that in mind as you're sharing with me your thoughts about what ought to happen here. And it should be clear on the record, Mr. Holmes has bond. It's not that he's in the no bond status. He's had bond for a number of months, which says to me that's a bond he can't make. Judge Brooks may have felt that it was reasonable both for what she heard in the case, but also because of his financial situation, because he was working. Financially, it seems not to be a practical bond. That doesn't make it an impractical bond. It's just not one that Mr. Holmes can post at this time. With that said, what do you want to add?
Yes, Your Honor, just briefly on the Parsons case. On October 30th, 2024, when Mr. Holmes entered the home of the mother of his children, Jasmine Hunter, he was intoxicated, and according to Ms. Hunter, he began to whip her firearm around, accusing her of being unfaithful to her, and during the course of assaulting her, there was one round discharge from the gun. There were children present who also observed what was going on. And I would say, rather notably, although Mr. Holmes did not have a significant felony criminal conviction history, at the time of the October incident, he was out on probation for a June 7th, 2024 incident for which he pled guilty on January 13th of 2025. In that case, 24 CR 0035557D in state court, he had been charged with criminal trespass to property against Ms. Hunter was also the victim. In that case, he had broken out the windows of a home. And so there may, again, while there may be some indications that they do have the children together, and I will say, based on the note, my review of the notes of this case, in October of 2024, Ms. Hunter did not deny the allegations in the indictment. She did want to continue to have some contact with him as far as co-parenting the children, but nothing further. And I don't anticipate that to have changed since November of last year.
Okay.
And Your Honor, just receiving a note from ADA Dillingard that there may be also be a pending motion to revoke his bond in the drug case. And so all that being said, Your Honor, I believe that the bond that he has is a reasonable bond. Bond is not mentally punitive, but not also just one that he can afford. It just has to be reasonable. I believe in the totality of the circumstances, it's reasonable, and we ask that you keep it in place.
Thank you for reminding me on the motion to revoke bond. It didn't get heard, but Brad Malkin, who is one of the non-complex unit prosecutors, in January of this year, filed a motion to revoke Mr. Holmes's bond in the drug case. And it would assume it would be the newer bond as well, for his guilty plea to criminal trespass in the state court case you just mentioned. So we've got things pulling in opposite directions. Ms. Rio saying lower the bond so Bail Project can help out, and Ms. Dillingard's predecessor on the drug case saying got to revoke the bond in the drug case. Do you want to talk about that? That wasn't on the calendar either, to talk the motion to revoke bond. So I'm happy not moving forward with it today, but it's there.
Yes, if we can do that another day. So
Okay.
let me get the files now.
Got it.
Yeah.
Right. Okay. Mr. Holmes, anything you want to add? I don't want you to talk about the facts of your case. I'm not asking you to say, oh, that's not how it went down. That's not what today is about. Or you feel like Ms. Rios has covered it?
Yes, just it's not as extreme as I would say. It's
Okay,
alcohol
but that's
based.
you talking about the case. Don't do that.
I'm saying it's, I have a lot of responsibilities, just about it. I'm not that monster, should I say, but I have a lot of responsibilities. I understand the situation, but I do have a lot of responsibilities. My
Okay.
kids.
That's what happens when you have 11 kids.
I lost my car, I'm close to losing, my home, so I just, the money I did have, it took care of my kids, it's where I'm incarcerated, but
Okay.
it's running thin.
Okay.
Not a bother to no one.
All right. So here's what we're going to do. I need to give Ms. Charles an opportunity to reach out to Ms. Hunter to see if her perspective has changed sometimes. In a situation like this, what you might hear is that Ms. Hunter would like to see a lower bond, i.e. one that Mr. Holmes can make so that he can get out and start earning again and contribute more meaningfully to the upkeep of their shared child. But Ms. Hunter may want to balance that with the peace of mind she's had while Mr. Holmes hasn't been able to break the windows at her place, something he's admitted to, not even talking about the gunshot. And Ms. Hunter doesn't make the final decision, but I think her input is important. And so I'm going to give you an opportunity to do that. And then we ought to reconvene so we can talk about the state's half of the equation, which is the bond in the drug case should be revoked because of Mr. Holmes's new conviction out of state court. I need to give that a fair hearing as well. So, Mr. Holmes, I'm not changing anything right now. I'm not changing it in your mind for the good by lowering your bond. I'm not changing it in your mind for the worse by revoking your bond in your drug case, because that would make the bond in the assault case immaterial. You wouldn't be able to get out anyway. I need to give Ms. Rios a chance to look into the drug case, understand that a little bit more. I need to give Ms. Charles a chance to talk to Ms. Hunter. I don't know if while you've been in custody, you've been trying to talk to Ms. Hunter on the phone. That would be a bad choice. Don't change whatever radio silence you've maintained, assuming you've maintained radio silence, okay? All right. Ms. Rios, anything else on behalf of Mr. Holmes? We'll get the scheduling order in place on the assault case, and then we can reconvene. You and Ms. Charles can just talk to Ms. Nelson about when we want to get back in touch. And Mr. Holmes, we don't need to wait weeks and weeks to do this. The one thing you need to be comfortable with, assuming you are, is it may be the quickest way to get you back in here is going to be on a screen. We have these booths at the jail where you zoom in, and because I can't bring inmates over every day. So it may be that Ms. Rios and Ms. Charles talk and say, hey, we could have the next conversation about bond on date X. But that's one where we'd have to get you on a screen. As long as you and Ms. Rios should talk about that, but as long as you're all right with that, that might be how we have the second part of the conversation. Okay?
Yes.
All right. Thank you.
Thank you.
So Ms. Hamilton, is she here yet? Ms. Hamilton? Okay, we'll check. Let's push through a few others and see where we get. Are you ready on Mr. Cargo?
Yes.
All right.
No, I didn't.
Oh, we can do a different order if you want.
Make a quick
Can
announcement
you
on
put
Lieutenant Jones.
Yes.
I had said this would be a plea, it turns out it's not actually gonna be a plea today, Judge. So if we could just put this, I think Ms. Nelson had granted my request to be on an inquiry calendar, if we could just go ahead and throw on a trial calendar. Turns out he does want to work with Ms. Ross, to see if she can.
He does?
Yes.
Okay. If it was a plea today, he wasn't going to work with Ms., how is that going to
changed his mind a couple times. Judge.
Okay.
And so he would like to speak with her now.
Okay, just give me one sec. Oh, so he's been in close to a year anyway. So it could have been a plea anyway, but he wants to work. I'm all for getting him plugged in with the program. So you're okay. You did your waiver of arraignment pretty recently, but if we kind of fast track it onto a trial calendar, you all right with that? Does that work for you, Ms. Dilligard? You don't have to say yes.
I'm fine.
Okay, all right. We'll do that. Then is Ruben Rainey going to be a revocation?
Yes.
All right, then why don't we bring Mr. Cargo out, please? Yes, ma'am. Good seeing you. Hey, Mr. Cargo.
Mr. McBurney.
How are you? You're on that. There you go. Give me one second. Okay. Mr. Cargo, my understanding is you're prepared to enter a plea in your case. Is that right?
Yes, sir.
Okay, let's get everything going. All right, Mr. Cargo, for that to work, Ms. Dilligard, who's seated behind you, but you can see her on the screen, she will be putting you under oath, asking you a bunch of questions. You're familiar with the kinds of questions she'll be asking, and you just need to make sure you answer those truthfully. If at any point you've got a question of your own, let Ms. Rios or me know, okay?
Okay.
All right, and we'll see how this goes. And this is a plea to misdemeanor or misdemeanors, is that correct?
Yes.
Okay, all right.
Typing up the.
I am ready when you are, Ms. Dilligard.
Mr. Cargo, can you please raise your right hand to the best of your ability? Do you swear or affirm that statements or testimony that you should give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true and correct legal name for the record.
Daniel Benjamin Caldwell.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
Yeah, Zyprexa and Trileptal.
What do you take those medications for?
Bipolar schizophrenia.
Okay. How long have you been taking those while you've been at the jail?
The whole time.
Whole time. Great. When do you take them during the day?
Once in the morning, once in the evening.
Did you get it this morning?
Yes, sir.
Good. Are you feeling like you understand what's going on in court today?
Yes, sir.
And the medication helps you understand what's going on?
Yes, sir.
Good. All right. Thank you.
Mr. Cargo, how old are you and how far have you gone in school?
I'm 34. I didn't graduate. That's it.
How far did you go in high school?
12th grade.
12th grade? So you got close but didn't graduate?
Yes, sir.
Do you understand that you have been charged with the following offenses? Been charged with felony obstruction of law enforcement officers, a simple battery against a police officer, and public indecency?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to that charge?
Yes, ma'am.
And do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charge against you at a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to those charges?
Yes, ma'am.
Would you like any more time to discuss the case with your lawyer?
No, ma'am.
Are you satisfied with your lawyer's services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment and any all defects in the indictment for purposes of the plea?
Yes.
Mr. Cargo, do you remember having being arrested on these charges?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge which you are pleading guilty to today?
Yes, ma'am.
Just go over that really fast with you. One moment. For the simple battery and the public indecency, the range is 1 to 12 months. And for the willful obstruction, one moment, just double checking. It's 1 to 5 years. Is that your understanding?
Yes, ma'am.
Oh, well, as charged, the felony obstruction is 1 to 5. And I'm reducing that to a misdemeanor obstruction. The range is 1 to 12 months.
Yes, ma'am.
Do you understand that today you're entering a negotiated plea of guilty, which means that the state will recommend the following sentence to the court? Judge, the recommendation is to reduce the felony obstruction to misdemeanor obstruction for and for count 1 would be 8 months to serve. And on counts 2 and 3, it'd be 12 months probation to run consecutive to count 1. And the conditions of probation is for the defendant to receive a mental health evaluation and to comply with any treatment as prescribed from there, and then also 40 hours of community service.
Are the two 12-month terms, I know they're consecutive to the 8 month to serve, are they concurrent with each other?
They're concurrent with each other, Judge.
Got it.
Is that your understanding of the recommendation?
Yes, ma'am.
Do you understand that the court's not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yes, ma'am.
And do you understand that if there are multiple charges to which you're pleading guilty to today, that the court has the right to run those sentences consecutively to each other?
Yes, ma'am.
Do you understand that if the court decides to order a sentence that differs from the plea you were expecting today, that you have the right to withdraw your guilty plea?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering of a guilty plea?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
And you understand that if you're on probation, you must follow all of the special conditions of your probation?
Yes, ma'am.
Do you understand that if you fail to follow the special conditions of your probation, that you'll be subject to revocation of that probation for the balance of your sentence?
Yes, ma'am.
You understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, the right to appeal if convicted of these charges at a trial.
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them, and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
Yes, ma'am. Yes, no, ma'am. No, ma'am. No.
Mr. Cargo, how do you plead to the reduced charge of misdemeanor willful obstruction, simple battery against a police officer, and 1 count of public indecency in indictment number 24 SC 003885?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition?
Yes, ma'am.
And do you understand that for a misdemeanor charge, you only have 12 months from today to file that petition?
Yes, ma'am.
Judge, if this case were to proceed to trial, the evidence would show that on June 19th of 2024, officers was driving a marked unit into work, observed the defendant not walking in their crosswalk, but instead in the intersection in front of the precinct. Officers told him to get out of the street, and the defendant pulled down his pants and underwear, revealing his buttocks and private areas. Officers got out of their car to detain the defendant, but the defendant swung his fist at the officer. The officer ducked and had to use his taser to obtain compliance of the defendant. And all of that occurred in Fulton County, Georgia, Judge.
All right. Thank you. Good morning, Ms. Jackson. She's not in court. She's on the screen. I'm not talking to an imaginary person. Ms. Jackson, are you able to hear us?
Good morning, Your Honor. I was sorry, I was having problems unmuting and turning on the camera.
No problem. Thank you for joining us. Could you share criminal history information on Mr. Cargbo, please?
Yes, sir. He has 50 cycles. The last arrest was June the 29th, 2023 with the Martyr Police Department for possession of cocaine and possession and use of drug-related objects. Those charges were dismissed on September the 7th, 2023. He does have a prior felony conviction and a sentence. This one in 2023 for felony obstruction of an officer. He received first offender treatment in 2016 for felony obstruction of an officer. That case was sealed October the 18th, 2022. He does have misdemeanor convictions. This one in 2019 for giving false information to an officer, and one in 2018 for simple battery. And there was one in 2014 out of New York for disorderly conduct. So additional one in 2014 for theft by shoplifting. And there was another one in 2014 for possession of marijuana less than an ounce. Nothing in addition, Your Honor.
Ms. Jackson, did you say that at least one of those misdemeanors from 2014 was from New York?
Yes, sir.
Got it. Thank you. Ms. Rios.
Yes. Mr. Carbo is 34 years old. He's from Georgia, lived here majority of his life. He does not have any children. He has been stable on his medication since he's been in the jail. I did initially try to do behavioral health court, but he has a warrant out of Jonesboro, so he cannot go there. So what me and Ms. Ross came up with was that when he is released from Jonesboro, go get services for Pat. I have the address written down for him to go there. And for when he gets released, he'll have to go to misdemeanor probation, show up in person because he doesn't have any address or contact information. I'm also asking for his probation fees to be waived based on him not being able to, I'm not sure if he'll be able to work or have an income in the near future. And I think he is doing much better now since I know initially had some concerns. He's found that he's fine and he's been on his medication, and talking to him recently, he's been very much so coherent, understanding everything I'm saying, and we've been able to have meaningful discussions.
So thank you for all that. BHTC said yes, but because of the hold from Jonesboro, or does it depend what the hold was? Because we have gotten people into one of the accountability courts conditionally, and then they had to go deal with a hold elsewhere. And we put a hold on them once they're gone that says bring back. And when you come back, you start your participation in whichever one of the courts it is.
Well, they said that before they could even go forward to further screening, that hold needs to be figured out. That's what the email from
I believe you. That's not a consistent answer because we have had scenarios where, all right, he's got to go to Cobb to deal with what's going on. It's not a murder hold, but it's a hold for another thing, a shoplifting or a.
Yeah,
got
I
into
actually had a case just like that, and
Yeah.
they went and I think they're still there in Gwinnett County, so I'm not sure.
Okay, I'll chat with, not about Mr. Cardbo in particular, but just see why we don't have a consistent approach to that. Because given the number of cycles Mr. Cardbo has and for what, it sure seems like BHTC would be great. This sentence will get an evaluation-ish, but I've not ever seen those turn into a particularly robust treatment program, but we work with what we have. And he's got to go to Jonesboro anyway.
Yeah.
So, okay. Thank you for sharing that. Mr. Cardbo, any questions about anything we talked about?
No, sir.
Okay. What do you have down in Jonesboro? Do you know what they want you for?
No.
Okay. Ms. Jackson mentioned some trouble you had up in New York. Did you used to live in New York? What were you doing up there?
Yeah, I got family out there.
Okay. Were you visiting family or did you live there for a while?
I was out there just visiting.
Okay. Home is Georgia for you?
Yeah.
When you get out, do you have a place to stay or will Pad be helping you with that?
I got a place to stay.
Is that with family or with a friend?
With a friend.
Okay. Is it in the Atlanta area?
Yes, sir.
Okay. You understand that the sentence that I'm going to impose today is probation for the most part, but you won't get out right away because you have to go down to Jonesboro to deal with whatever that is.
Okay.
I mean, you'll get transferred down there. You're not going to get stuck in Fulton, but you won't be released from jail and told when you're ready, go on down to Jonesboro. You'll be transported down there to deal with whatever those charges are.
Okay.
Okay. All right. Well, Mr. Cardbo, I find there's a factual basis for your plea. In June of last year, you got upset at some officers, did some things you shouldn't. Sounds like you got tased. That can't have been fun. I also find that your plea is voluntary. That means no one's forcing you to do that. And you understood that because at first you said yes and you meant no one's forced me. You agree no one's forcing you to enter this plea?
Yes, sir.
Okay. And a knowing plea just means you've understood what we've talked about. Do you feel like you've understood a conversation?
Yes, sir.
Okay. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, sir.
Ms. Dilligard?
Yes, Judge.
All right, Mr. Cardbo, is it okay if someone electronically signs your name to the indictment indicating your misdemeanor plea?
Yes, sir.
All right, we'll do that. I am going to sentence you on count 1, which has been reduced to a misdemeanor, to 8 months to serve. And on count 2, which is another obstruction of officers, also to 8 months to serve. Those two will run concurrently with each other, meaning at the same time. And then finally, count 3 will be 12 months probation, and that's going to run consecutive to count 1. So you're going to be on probation for 12 months. That was for Moon and the officers. You're going to have 2 conditions of your probation. Well, there's always one, which is don't get arrested for anything. But the 2 special conditions are, number 1, you're going to meet with a doctor or a counselor and have a mental health evaluation to see if there's any treatment. Keeping up with the medication is one, but whether seeing a counselor or someone would help. That'll be the first condition. And the second is that you're going to need to do 40 hours of community service. I will waive your probation supervision fees. Have you been working recently or is getting a job kind of tricky for you?
It's tricky.
Okay. What's the last job you had?
I was a teenager at BYS.
Oh, so way back when?
Yeah.
Okay, got it. So we'll waive the probation supervision fees. Like I said, you're not going to go to probation right away because you got to go down to Jonesboro to figure out what's going on there. Okay?
Okay.
Ms. Rios, anything else on behalf of Mr. Cardbo?
No, Your Honor, thank you.
Ms. Dilligard?
Nothing further, Judge.
Any questions, Mr. Cardbo?
No, sir.
All right, you ought to be on your way to Jonesboro this week. If not, reach out to Ms. Rios and we'll figure out what the deal is.
Okay, thank you.
All right. If you want, you can bring Mr. Hutchins to the door. It's not mandatory. And then are we ready on Rainey?
Yes, Judge.
Hey, Mr. Hutchins. I'm Judge McBurney, and your case was mistakenly assigned to me. Mr. Garland was a very vocal advocate on your behalf on Friday, and reached out to my staff to say, hey, we got to see a judge on Monday to talk about Mr. Hutchins's case. He didn't do anything wrong other than he was sort of barking up the wrong tree, and someone put your case on my calendar. I believe any bond issues, and that's what Mr. Garland wanted to talk about, was bond, need to be heard by Judge Glanville. It's a colleague of mine. I've shared that with Mr. Garland, so he knows to whom he needs to reach out to try to line something up. I just wanted you to know why you got brought over today, what you've been doing back there. Mr. Garland was working hard to get you that bond hearing. Just isn't with me. That case has been assigned, your case has been assigned to Judge Glanville, I believe, for anything to do with bond. It's not indicted yet. I don't know if it will be indicted, but while it's in this pre-indictment status, I think it will be with Judge Glanville for anything to do with bond. All right?
Do you know when that's gonna be?
I don't. Mr. Garland will figure that out and he'll be in touch with you. But he worked very hard to get you over here today, a little too hard, and convince someone to put you on my calendar. My calendar is for folks who had you had a first appearance on Thursday in front of Judge Brooks, and she deferred hearing bond. She's not allowed to hear. She's a magistrate judge, and she cannot hear bond on charges like yours. That has to go to a superior court judge. And Mr. Garland tried to get you in here, but he was a little too fast. So he will be in touch with you. I have sent him an email explaining what's going on, and that he need not come all the way down here today because I won't be hearing your case for bond. So he'll work with that other judge. All right?
Okay, yes, please.
All right, ready on Rainey?
Yes, Judge.
Okay. Did you have stuff you need? Did you give your stuff to Deputy Gordon? He's got it. All right, he'll get it to me.
Judge, I want to get a warrant signed for a beauty swap for Thomas Hutchins, arguing in this court on the basis.
You just looked at him. He was that guy right there. That's Thomas Hutchins. Okay, we'll do that in a sec.
Yes, sir. Thank you.
Don't take Hutchins down. Okay, Rainey, please. Ms. Wood, are you here this afternoon or you're just here this morning? This afternoon is different lawyers from your office?
Yes.
Okay, then we'll take care of, I have a noon Zoom, but I think we can get
This will be
through.
quick.
Oh, Rainey will be quick. Hamilton,
Oh,
that's, I don't know, she's apparently in the building. She needs to come on up. I just don't know how quick that'll be. But we'll work through it.
so I can stay at the meeting.
Okay.
Was he to sit or is he to stand?
Mr. Rainey, is it better for you to be sitting? Well, we're not going to talk very long, but I want you to be safe and comfortable. Is it better to sit or are you okay standing? Okay, why don't you work your way to the podium, please? All right, let's go on the record. This is 23 SC 188930, State versus Reuben Rainey. Mr. Rainey is here in court with his lawyer, Ms. Wood. Mr. Rainey, in July of last year, I signed a probation warrant that alleges that you became hard to find, basically. Those are my words, but we had an address for you. You weren't there. The probation officer left a letter saying you got to come on in. You didn't come on in. And so somehow, whether it was you moved or your roommates weren't getting you the mail, you were hard to find and you need to be easy to find for probation. I'm gonna let you talk to me in just a sec. I'm just letting you know the issue. So it's not the most serious thing. Sometimes with probation, it's another burglary. Oh, you can't do that while you can't do that ever, but you can't do it while you're on probation. This is one where you became hard to find and we need to fix that and make sure if your probation officer needs to talk to you, it's a phone or you're at the address, you need to not be scarce for probation. That's the allegation. Ms. Wood, is Mr. Rainey admitting that in June of this year, he wasn't so easy for probation to find?
Yes, Judge, we're admitting to the technical violation.
All right, and that's what it is, a technical violation. What are you recommending that we do?
I'm asking for the court to revoke 60 days and reinstate. Judge has been at 57 days. He thinks that it's the correct address in their system. Is this the one you were telling me, 453 Wilson Mill Road?
Yes, ma'am.
Okay. I'm not exactly sure what the miscommunication was last summer. He was telling me that when he was released, he was working various jobs. So I'm not sure if perhaps his schedule just wasn't lining up properly with probation. And then at some point between then and now, he was actually hit by a car.
Ouch.
He's actually in a wheelchair in his booking photo, and now he is with the walker. So he's been battling through that, but he understands that he has got to keep in touch with probation. So we're just asking for 60 days revoked and reinstated.
Okay. Ms. Simpson, how much time is left on Mr. Rainey's case?
He has 5 years, 7 months, and 10 days.
All right, so you got some time left on that sentence. Ms. Dilligard, your view on what ought to happen in Mr. Rainey's case?
Judge, the state, after speaking with probation, agreed that our recommendation would be to revoke 3 months and to reinstate his probation.
Okay. Ms. Simpson, how has Mr. Rainey done on probation other than this situation?
He's not been revoked.
Okay. Any issues? I mean, people cannot be revoked, but with Palm, there could have been.
He never completed his initial required community service hours, so that would be a condition that he needs to complete.
Okay. Okay. Oh, I remember this case. So you're supposed to stay away from the school, and you were supposed to do 120 hours of community service. Had Mr. Rainey done any?
The last notation says he only completed 2 hours.
2. Well, that leaves a bit left. Okay. Mr. Rainey, first tell me how you're doing having been hit by a car. I'm sorry that happened.
I'm doing so-so, going through therapy, learning how to walk, use my left hand again.
Okay. What part of you got hurt the most?
The whole left side. Sir.
Whole left, so you got hit on the left side.
I had 2 major surgeries.
Ouch. Okay. And what is the prognosis? Should you be able to walk better in the future, or it's hard to tell?
It's about 2 or 3 more months. My bone on both arm and leg should be fully healed in about 3 or 4 more months.
Okay. Well, I'm sorry you went through that. So this address seems to be creating some trouble for you. I have the same address that everyone seems to have, which is 453 Wilson Mill Road. What is at that address?
Me and my dad stay.
Okay. Does your dad live there full time?
Yes, sir.
Okay, because the probation officer indicated that he or she, I think it's a she, left a letter there saying you got to report, and it doesn't sound like you got that letter.
I didn't get that letter, sir.
Okay. Did you have a phone at the time? This is back in June, so this is before you got.
I used to call my probation officer on my dad's phone.
Okay.
He'll call me on my phone.
Got it. Okay. But your probation officer at least had phone numbers for you. It might be your brother's phone or your dad's phone. Okay.
He always call me and let me know that he coming by, and I'll be there when he come by.
Got it. Okay. So it sounds like in the past it worked well. We just need to make sure it continues to work well. Doesn't seem like you're going to be getting out and about too much for a little while. But when you are released from jail, will you be going back to Wilson Mill Road?
Yes, sir.
All right. Okay. Any questions about anything?
No, sir.
All right. Ms. Wood, anything else on behalf of Mr. Rainey?
No, Your Honor.
All right. Mr. Rainey, I do find that you violated the terms and conditions of your probation. And while I understand the recommendation of 90 days rather than 60 days coming from the state and probation, given your medical condition right now, I think you will recuperate better at home rather than at the county jail. And so I will go with the 60 days. But you should know, if we're having to talk again soon because probation couldn't find you, it's not going to be just a few months. It'll be, you're showing us that probation doesn't work for you. So make sure your officer has good phone numbers and maybe engage with the officer about when you say you sent a letter, what does that mean? Like, where'd you leave it? Was it on the front porch? Was it, I don't know if 453 Wilson is like townhomes and maybe she put it in a different place, but ultimately it's on you to stay in touch with the officer and not the other way around. Okay? All right. Any questions about any of that?
No, sir.
All right. So I am revoking 60 days, reinstating the balance. And remember, you've got community service to do. That doesn't mean right away with a walker, you have to be out there doing things, but that balance is not going away. It's an obligation you have. It's what you committed to when you entered your guilty plea. So as you get healthier, make sure that's part of your routine. Okay? Ms. Simpson, anything else?
Your probation officer has changed.
Oh.
And so I will get that information to you.
Yes, ma'am. Thank you.
Ms. Dilligard, anything else?
Nothing further, Judge.
Ms. Wood?
No, Your Honor, thank you.
All right, Mr. Rainey, you're going to be getting out soon. Take care of yourself.
I'll come back there. I'm ready, doctor. Wait.
Mr. Royals, how are you today?
Supercalifragilisticexpialidocious, sir.
Great. That doesn't fit with the weather, but I'll take it. That's your MO. How's everything going in the clerk's office? Excellent. I'm checking out Morris Brown. I like it. All right. The Wolverines. Everything good with the grand jury? Did they miss their judge?
Thank you.
I bet. All right. Well, I'm happy to check on them at any time. Here you go. Take care. I kept my spreadsheet, so I'm good.
Yeah, you're good to go.
Let me knock out, all we have left is she up now? No. Okay, good. So I will stay here and do some of the paperwork if you want, or should I not stay here and do the paperwork? No. We're good? Okay. All right. Oh, well, that's what we're gonna do. I was gonna do the warrant. You're talking about so they can do the. Okay, well, let's knock that out. So I need to sign something from the DA's office, sign something from the DA's office, and then we'll do that. All right. He has the paperwork? Okay. Okay, maybe he took it and has like a special table back there. Or maybe he left it with Mr. Hutchins. You got all the paperwork? Oh, Ms. Niles has it. All right, I'll go get it. Let me go read through that stuff. I'll bring it back out here. We'll take care of it and we'll do Ms. Hamilton. Here comes Ms. Niles. Da-da-da. Thank you.
Oh my God, that's mine. Thank you.
So how do you think the Zoom session on mental health and wellness went?
I thought it went great.
Good.
Yeah, very helpful. So thank you for being a part of it.
Happy to do it. Never heard of a lieutenant investigator. Is that the way they're creating a hierarchy? All right, Investigator Cruz, you swear or affirm the contents of your affidavit are true and correct to the best of your belief and knowledge?
Yes.
Is there a colonel investigator or a major? Not yet. Excellent. Whose idea was that?
Yes, matters.
Yeah, all right. All right, so you need to come sign this, and then you have what you need. You have your equipment to do what you need to do? Good. Deputy Gordon will get you back there. So how do some of these come to you? Like this woman had a murder trial 20 years ago, and now she's coming out of the woodwork saying, could you seal my file?
Yeah, a lot of the older cases are people who like trying to get assisted living.
Oh, and they run the history. I mean, she's found not guilty, so
Yeah.
but that would be a hiccup on your murder. Okay, got it.
Rather be hard to see when.
So housing or some benefits or something.
Yeah.
Got it. Wow, it was Judge Moore way back when. Oh, it was a bench trial.
Sometime from facing saying that she's still.
I want to know which one.
I'll ask him.
Are we still pretty much at 48, 72 hour turnaround if someone is referred to the adult diversion program in terms of are they in or out?
Yeah, roundabout. Yeah, as far as I know, I do record restrictions only. They still have a separate diversion unit, but I believe.
Okay, I didn't know if you were we met with Ms. Toole recently because we had been hearing mistakenly from others that, oh yeah, it's weeks delay. We can't, certain people were saying, I can't get an answer out of them. And Ms. Toole said, that's not right. If you do what you're supposed to do, fill out this form, within 2 days-ish, we let you know the person is in or they're not in.
Yeah, that's more.
Okay.
That's your honor.
All right, here you go. You can come on up.
Thank you. I expect to have handful more, please? Would it be okay if I want later this week?
Yeah, I'm on all week long.
Thank you, Your Honor.
You bet.
So much. I appreciate it.
Take care.
See ya. Thank you.
How are things?
Yes, right. Once, if we get it, I can just request it. So. I mean. Yeah, the final delusion.
He was a little bit, but it's not. Yeah, I can't come down to 4.
Is all that's left Ms. Hamilton?
Yes, Judge. I
Okay.
think for me at least.
I think that's, let's just go through the calendar again. New Meister, Holmes, Hamilton. Yeah, this should be all that is left for this morning. And we have the presiding bond calendar this afternoon. Oh, and then Mac Ransom. Who's handling it? Maybe Mr. Melnick
It's
is.
Mr. Melnick.
Okay. Because he was going to be here at 1:30 anyway for one of these bonds.
And then we have Leach, right?
Yeah.
Oh, Leach. All right. I'm not going to be able to get to that before I have to take this call.
Okay.
So do you want to come back at you want to come back at like 1:20? So we do that before those bonds?
Yeah, I'm not leaving the building, so.
Okay. You're actually can stay right here. I'm just letting you know at noon, I have to get on this Zoom about accountability courts. And then we got to be down for an hour. The presiding stuff is down for an hour just to give people a break. So it's sort of noon to 1, and then we can do Leach. What are we doing with Leach? Please?
No, this is probation revocation.
Oh.
Remember last time we didn't have the program, I have the program, it's in his letter and all his dates in custody, so they wouldn't, probation 1 year revoked, I believe, or he's been in for 1 year and now he has a program, and I also sent the transport order.
Great. What's the program?
Whole house.
Oh, okay, good. Oh, that's right. It's on this piece of paper. All right. Have you, Ms. Dilligard, had a conversation with Mr. Melnick about Mac Ransom or?
I have not spoken with him. No, Judge, I have not.
Okay. Well, he'll be here at 1:30. What did Mr. Mac Ransom allegedly do? New charges.
2 new offenses, Judge.
2, yeah, look at that. Okay. Done?
Yes, sir.
Excellent. So if Miss Hamilton is here, if we can do the swap out, problem is I got to get on a Zoom call at noon. So I'm wondering if we want, I have no idea what time it is. The computer says it's 56.
I'll tell you this morning.
That's accurate? Okay. My guess is though, Ms. Wood is going to need to chat with Ms. Hamilton some, and we won't have time to do everything we need to do. So I'm wondering if we want to say we'll start back up again a little after 1. I can be here at 1, but if you want a longer break, I can make it 1:10. And that's when we could do Leach and Hamilton, and people just do a lunch break now. Does that work?
That's fine, Judge.
Would you like to see Hamilton now before, you work with Deputy Gordon about when you talk with Ms. Hamilton?
Thank you, Judge.
I'll be back a little after 1 to take up Hamilton and Leach. All right?
Thank you.
Work for everyone?
Mind signing my returns?
I don't think I've ever signed a return so soon after signing, but why not do a round trip. Let me mute the